Hi, I'm David Cantor with the Law Offices of David Michael Cantor. Today I'm going to be talking about the charge of kidnapping. In Arizona, if a person restrains another person with the intent to accomplish certain goals, then that is kidnapping. And these goals are listed in the statute. For example, the most common goal is to keep somebody from calling the cops during a felony. That's kidnapping. If you hold somebody as hostage for ransom, such as the coyotes who are holding a lot of illegal immigrants who come over the border, that qualifies. If you restrain somebody for the purpose of sex, clearly that's kidnapping, or for robbery or assault and you restrain them. These all qualify as kidnapping. Now, this is overcharged a lot when a boyfriend and girlfriend are arguing and the girl wants to leave and she's been drinking and has her keys and the boyfriend's, no, don't leave, don't leave. Sometimes you'll hear this is charged as kidnapping, which is ridiculous. Other times it will be charged as unlawful restraint. Either way, there's a lot of defenses. Now, the punishment on this, if a gun or a knife was involved, then the person's looking at 7 to 21 years in prison. 10.5 is presumptive. If there's no deadly weapon, then the person can face probation with 0 days in jail up to 1 year in jail, or prison with 3 to 12.5 years in prison. And what I mean by that is it's charged as a weapon, but it turns out it's not a deadly weapon. If there's a gun or a knife involved and no physical injury, and they're released by the person, meaning they're being held, not injured, and then they get released, then they're facing 4 to 8 years in prison. If there's no deadly weapon involved, yet the person voluntarily releases the person they kidnapped, they're facing probation with 0 days in jail up to a year, or 1 to 3.75 years in prison. And lastly, if the police negotiate the release and the person has a deadly weapon and they release the person unharmed, then it's 5 to 15 years in prison. If they release them and they had no deadly weapon, but the police negotiated it, the release, then it's probation with 0 days in jail up to a year in jail, or a prison of 2 to 8.75 years. So there's a lot of different things going on, and that's why you need to talk to a lawyer who knows what they're doing. Now, the defenses. Clearly, if there's no intent to achieve one of the listed goals, then you have a defense. It's not a true kidnapping. For example, there's no ransom, no hostage, no sex, no robbery, no assault. And I don't mean a simple domestic violence assault and you wouldn't let somebody leave. That's where we see this overcharged. And that's where we can defend this quite effectively. Usually we see these in custodial interference or domestic violence misdemeanors that are overcharged. Custodial interference means you're holding the kid and you're saying, look, I'm not going to take you home because mom's been drinking and it's not safe right now. That doesn't qualify as a kidnap. Maybe a custodial interference, even then there's defenses. Now, we have lots of victories in this particular area, and if you go to our victory section of our website, you can look at some of those. If this situation applies to you, a family member, or a loved one, either give us a call or go to our website at dmcantor.com, contact us for a free initial consultation.